filing suit for declaration and permanent injunction. This is a suit for declaration, permanent injunction, my lord. Prior to filing the suit, my lord, the petitioner had filed one more suit, that is suit for permanent injunction. With respect to the permanent injunction, my lord, the suit has been dismissed. This suit has been dismissed. With respect to the possession, it has already been determined that the petitioner is not in the possession of the property. Now, my lord, we do not dispute that with respect to the extent, but with respect to the boundaries, we are disputing, my lord. That is, the to the southern side of the plain schedule property, there is 20 guntas of land which is exclusively reserved for the cremation purpose, where villagers are using. If the status quo continues, my lord, more than 600, 700, more than 1,500 people are there representing the community, and if they are not able to, and if they, with usage of the
In
status
respect
quo,
of the very same burial ground, which is part
Please.
of the earlier suit schedule,
please, my lord.
that suit was dismissed.
Yes, please, my lord.
Where is that?
My lord, at page number 51, my lord, of the writ petition, there is findings recorded by the Land Appellate Court. Land miscellaneous idralli. My lord, I'll kindly permit me to read it, my lord.
When was that suit dismissed?
My lord, it is a 2008 suit, my lord, 2006 suit, my lord. It has been dismissed and it has attained finality.
When was it dismissed?
We do
You
not
don't
know
have the
exact date, my lord.
Yes. When was this suit filed?
2006, my lord. Earlier suit.
Present suit.
Not present suit, earlier suit.
I'm asking you when is the present suit?
Present suit, my lord,
2016,
2016, my lord.
So for the very same property, you have filed a declaration now.
Please, this is
And now you-
comprehensive suit.
Correct.
Previous
It's
one
a
was the-
comprehensive suit, but the suit schedule property is one and the same.
And it's the
And
same.
your suit for injunction is dismissed, holding that you are not in possession of the property.
Yes, Your Lordship.
Holding that boundaries are not matching.
So the same applies now. The same thing you have filed now also.
No, my lord, the difficulty is that in the guise of accessing the crematorium or whatever, the entire extent of 5 acres changes, my lord, being interfered with. I'm not in dispute of the 20 guntas kharab. The dispute is
So
that
in that case, you should file an appropriate application in that regard.
I filed for the entire extent, not only 20 guntas, my lord. Their dispute is in
My lord.
respect of only 20 guntas. Now my
That's what I'm saying. In that case, you should have restricted that. Apart from the 20 guntas, you should have sought for injunction.
no, my lord, I filed for the entire extent.
And then in that case, it can't be.
Lord, in that case, my lord, it may be recorded that my land, which is not
So
in
you
dispute.
are only concerned with that Karab land of 20
Karab land,
guntas.
yes,
Please
Your
go
Lord.
ahead.
It's a purely
We are
government
not
land, Your Lord.
disputing the extent of the petitioner, but with respect to the 20 guntas of land, my lord, I am concerned with that 20 guntas of land, my lord, because, my lord, the villagers, my lord, there are more than 2,000 people, and ST people are residing, and in view of the status quo, they are trying to interrupt me from doing my cremation
No, if
activities.
the court says, no, what about the demarcation of that land? If that land is demarcated,
My lord, when I went for the survey, my lord, he interrupted me from performing this survey.
My contention is that they're trying to dispose me in the guise of survey.
How is
They're
it possible, my lord?
interfering with my
If they are
usage.
no, it is like this. In the light of the judgment and decree in an injunction suit, no, you're not in a position to say that this is what I want. Now, what is your suggestion and what is that you want so that their
Lord,
protection is also protected?
Admittedly, it is Karab land. So the question of possession does not arise. My extent.
Their case is now, even that Karab land, whatever it is, now the boundaries are in dispute because you're also claiming some part of the Karab land. So how do we demarcate the Karab land now?
That is the entire suit, man. That is the entire suit.
There can't be any injunction now in that case.
So that's the reason, my lord.
No, it is not even your case that with respect to the other property of your, how much is the total extent? 5 acres.
6 acres,
6
4
acres.
So that's not even your case that they're interfering with your other part of the land.
They are. That's the case.
Hmm.
That's the difficulty, my lord. My entire
That is which
extent
is
is
adjacent to that Karab land.
adjoining. Yes.
Yes. So now there can't be any injunction in those circumstances.
That's the reason this honorable court granted status quo.
How can there be a status quo?
Oh, my lord,
When a person who has lost a suit for injunction, can there be a status quo in an interlocutory application? When your main suit on the merits of it is already dismissed, how can there be a status quo?
No.
Can you be in a better position in an IA?
that
Please
suit-
come. Where is the order impugn?
My lord, at page
Page-
number 44,
Agreed
my
with
lord.
orders passed in MA number 8 of 2019 dated 1st June 2019. The plaintiff is before this court. The plaintiff had filed the suit seeking declaration and injunction in respect of an extent of 6 acres,
4 guntas.
6 acres, 4
4
guntas.
guntas. 4
6
guntas.
acres, 4 guntas of land. It is his case that the defendants are interfering with his possession and enjoyment of the property. Where is the trial court's order?
It's in Kannada.
It's
Huh.
in Kannada.
Trial court by order dated 20th February 2019 had granted the injunction, interim injunction as prayed for. Aggrieved thereby, the defendant had filed MA number 8 of 2019, date 8 of 2019, and that appeal came to be allowed by order dated 1st June 2019, which is impugned before this court. While allowing the said MA, the court has observed that earlier, in respect of the very same property, the petitioner plaintiff had filed OS number 218 of 2006 for the relief of permanent injunction. And the said suit was dismissed, holding that the plaintiffs have not proved boundaries of the suit scheduled property, and the said judgment was confirmed in RA number 89 of 2008. Further, the court also observed that the copy of the report of the surveyor produced by the fifth defendant reveals that the land which was sought for cremation of villagers is situated toward the southern side of survey number 90. Further, the copy of the Mahajar produced by the defendant reveals that 20 guntas of allowable land is situated toward the southern side of survey number 90, and boundary for the said 20 guntas of land is also shown as north by survey number 90 of Verehalli. Further, the sketch prepared by the surveyor reveals the fact of existence of 20 guntas of Karab land towards the southern side of survey number 90, and it belongs to Taraka Channel, and the said land is claimed by the villagers of Ankantapura and Hari people and sought for its grant. Even that document also discloses that towards the northern side of 20 guntas of land, the land of survey number 90 is situated. Further, a certificate is issued by the Gram Panchayat of Hirehalli village, prima facie, reveals that the government Karab land measuring 20 guntas is situated towards southern side of survey number 90. And the said land, which is situated in between Taraka Channel and survey number 90, has been used for cremation by the villagers. And the said 20 guntas does not belong to survey number 20. As such, the appellate court had reversed the order of the trial court and dismissed the application filed for interim injunction. A coordinate bench of this court on, well, again, is that the present writ petition is filed. A coordinate bench of this had granted status quo on 19/9/2019, and the said interim order has been extended from time to time. Land counsel appearing for the petitioner plaintiff submits that they've been enjoying the status quo order right from the year 2019. As such, and from the last 6 years, they've been enjoying the status quo order granted by the court. As such, the same may be made absolute, and a direction may be granted to the trial court to proceed with the matter. He submits that the petition is a owner of the property. The injunction, the judgment that's passed in injunction suit has no bearing in the present suit, which is a comprehensive suit for declaration. He submits that the villagers, under the guise of the said Karab land, are trying to are interfering with his land, which made him to file the present suit.
One submission. Lord, in my schedule, Kharab land is not included. And that observation has been made. But it says, it is very clear from the said document, the land measuring 6 acres, 4 guntas, no burial ground is existing. Which they are also
Yeah.
not disputed.
No,
I am disputing it. Towards the southern side of the channel, my lord, in the plain state.
it is submitted by the land council that in a 6 acres, 4 guntas of land, there is no Karab land, and the Karab land is adjacent to the, adjoining the land of the petitioner. And under the guise of the said Karab land, they're interfering with his,
It's also observed in the
with his land. Next para. Land council appearing for the, respondent defendant submits that, and the guise of the status quo order. This status quo, because of the status quo order, the entire villages are put to a lot of hardship. It is submitted that they've been using the land for the cremation purpose. It is submitted that the Appellate court had rightly, had rightly set aside the order of the trial court when the suit for injunction filed by him in respect of the very same land and very same defendants has been dismissed, and when it has attained finality, when the appellate court has confirmed the order of the trial court, he submits that continuing the status quo order is not, will cause a lot of prejudice to the defendant, and petitioner, the petitioner is not entitled for such a relief from this court. Thanks for having heard the counsels on either side. There is a material on record. There is no dispute about the fact that, in respect of the very same property and against the very same defendant, he has filed a suit for the plaintiff had filed a suit for injunction, which came to be dismissed, and against that an RA is filed, and RA is also dismissed. Hence, an order passed in the injunction suit has attained finality. There, the court has also observed in the injunction suit that the boundaries of the petitioner property are not clear. Then, as such, injunction was not granted. Now, in the suit for declaration, the idea that is filed with the petitioner plaintiff is also in the similar grounds, in the similar lines. The trial court, without considering the said fact, had granted injunction, and in the considered opinion of this court, the appellate court had rightly considered these issues, the issue of granting injunction in favor of the